Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. The court handed down its decision in Pitchford v. Cain on May 28, 2026, and it went for Terry Pitchford, 5-4, with an interesting split. Justice Kavanaugh wrote for the majority, joined by Chief Justice Roberts and Justices Sotomayor, Kagan, and Jackson. Justice Gorsuch filed a dissent, joined by Justices Thomas, Alito, and Barrett. The bottom line? The Mississippi Supreme Court acted unreasonably when it ruled that a death row inmate waived his right to challenge racially discriminatory jury selection because the trial court itself never gave him the chance to make that challenge. Pitchford's case now heads back to the lower courts.
This one matters. A man sits on death row, and the question at the heart of this case, whether courts can call something forfeited when the judge blocked it from ever happening, reaches every courtroom in America where a defendant tries to challenge racial bias in jury selection.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. November 7th, 2004. A small grocery store near Grenada, Mississippi, the Crossroads Grocery. Two black teenagers walk in. Terry Pitchford, 18 years old. Eric Bullins, 16. They intended to rob the place. Bullins pulled a gun and fired 3 shots at the store owner, a white man named Reuben Britt. Britt died. Pitchford fired a separate gun, loaded with what's called rat shot, though whether he aimed at Britt or fired into the floor remained contested at trial.
And the two men faced very different fates.
Very different. Bullins, who fired the fatal shots, reached a plea deal and received a 20-year sentence. Pitchford faced a capital murder charge and the death penalty.
And here's where the prosecutor's conduct becomes central to everything. At Pitchford's 2006 trial in Mississippi State Court, if you remember from our preview episode, we walked through this in detail. Prosecutor Doug Evans marked up his juror list before the strikes began, writing the letters W and B next to each prospective juror's name. He flagged their races in writing before removing a single person.
He literally wrote it down.
Yikes. And then he struck 4 of the 5 eligible black potential jurors. The jury that convicted Pitchford and sentenced him to death contained 11 white jurors and 1 black juror, in a county that counted 40% black residents.
So, Pitchford's lawyer objected.
She did. Defense attorney Allison Steiner raised what the law calls a Batson objection. Batson versus Kentucky, that's the landmark 1986 Supreme Court case, stands for the rule that prosecutors cannot kick jurors off a panel because of their race. The Equal Protection Clause, the constitutional guarantee that no state can treat people differently based on race, bars it. And when a defense lawyer raises a Batson challenge, the law lays out a 3-step process.
Let's walk through it. Step 1. The defense shows a pattern that looks like discrimination. Here, 4 of 5 black jurors struck. Step 2. The prosecution explains each strike with a race-neutral reason. Step 3, the critical one. The defense gets to challenge those reasons as a cover story, what lawyers call pretext, and the judge decides whether the explanations hold up.
So the defense gets to punch back at the prosecutor's explanations.
Exactly. Here, the prosecutor gave his reasons. 1 juror came back late from lunch and had a history of mental problems. 2 others had brothers convicted of violent offenses, and the 4th shared characteristics with Pitchford. Similar age, children the same age, never married. The judge heard each one and declared them all race-neutral. And this is the crux of the entire case, the judge immediately pivoted to the defense's peremptory strikes. Step 3 never happened. Defense counsel never got to say, those explanations don't hold up, and here's why.
She tried, though, multiple times. At the close of jury selection, Steiner sought to raise the Batson issue again. The trial court cut her off twice, and then the judge told her, I think you already made those, and they are clear in the record. The message was, your objection sits on the record. The court then announced it found no Batson violation and moved on.
So the judge assured her the objection was preserved, and then never actually ran step 3.
This issue played out at oral argument on March 31st. Justice Sotomayor pinpointed something critical in that transcript. The judge revealed his own misunderstanding of the process. He told the parties right at the start that his normal practice on Batson challenges was simply to have the state give race-neutral reasons, as if that alone ended the inquiry. Justice Sotomayor put it this way during argument. She said the judge never paused to give Steiner a chance to address pretext and never made the required Step 3 finding. The argument confirmed what the trial record showed. For this judge, race-neutral reasons equaled no Batson violation, full stop.
But what happened on appeal?
The Mississippi Supreme Court affirmed Pitchford's conviction and death sentence, and it did so by ruling that Pitchford surrendered, his right to make a Step 3 argument because his lawyer never argued pretext before the trial court. Justices Graves and Kitchens dissented, saying no waiver occurred and the prosecutor's reasons amounted to pretext.
Pitchford then filed a federal habeas petition. That's a challenge in federal court arguing his imprisonment violates the Constitution. Federal habeas operates under a 1996 federal law called AEDPA, the Anti-Terrorism and Effective Death Penalty Act, which sets a very high bar. A federal court can overturn a state court ruling only if it amounted to an unreasonable application of clearly established federal law or an unreasonable factual determination. The U.S. District Court in Mississippi granted Pitchford relief, finding the Mississippi Supreme Court crossed both lines. The Fifth Circuit reversed. The Supreme Court took the case.
So what did the court decide, and how did the majority get there?
Justice Kavanaugh walked through 3 core moves. First move. The trial court never ran Batson's third step. The majority cited Flowers v. Mississippi, the 2019 case involving the same prosecutor, Doug Evans, where the court reversed a conviction after Evans removed 41 of 42 black jurors across 6 trials of the same defendant for the proposition that the job of enforcing Batson rests first and foremost with trial judges. Here, the trial judge failed that job. He ended the inquiry at Step 2, declared the reasons race-neutral, and moved on without ever inviting defense counsel to respond.
And the second move?
No waiver. The majority acknowledged the bedrock rule that a party must raise objections at the trial court level to preserve them for appeal, and confirmed Batson claims follow that same rule. But it held that Steiner didn't waive anything, because the trial court affirmatively blocked her from making the argument. The district court captured it well. The trial court thwarted, though likely unintentionally, defense counsel's attempt to argue pretext. And critically, the judge then told Steiner her objections were already clear in the record. Given that explicit assurance, the majority called it unreasonable for the Mississippi Supreme Court to turn around and call it a waiver.
I love that. You can't tell someone their objection is preserved and then use the preservation as proof they forfeited it.
Exactly the point. Third move, and this one addresses the state's main argument on appeal. Mississippi argued Pitchford preserved his general Batson objection, but separately waived his Batson pretext argument. Kavanaugh's response, that slices Batson way too thin. Once the prosecutor offered race-neutral reasons, the Batson objection and the pretext argument became the same thing. Think of it like this. If someone accuses a store of overcharging you, and then the store manager gives an explanation, saying, I accept that you complained but reject your argument that the explanation was wrong, treats one thing as two. The defense's right to respond necessarily includes the right to say those explanations don't hold up.
And the AEDPA piece, how did the majority handle the deference question?
Kavanaugh leaned on a line from Miller L. versus Dretke. That's a 2005 case where the court reversed a Texas death sentence after finding evidence of racially motivated strikes. The line, deference does not by definition preclude relief. AEDPA demands respect for state court rulings, but not abdication. In light of the full record, the skipped Step 3, the judge's assurances to counsel, and the repeated attempts to preserve the issue, the majority concluded the Mississippi Supreme Court's waiver ruling qualified as unreasonable. So the majority reversed.
Reversed the Fifth Circuit, 5-4, and remanded for further proceedings consistent with the opinion. The court explicitly declined to rule on whether the prosecutor actually discriminated. That question goes back to the lower courts. Now let's walk through Gorsuch's dissent, because it's a serious one. It is serious. Justice Gorsuch, joined by Thomas, Alito, and Barrett, argued the majority effectively gutted AEDPA's protections under the guise of applying them. The dissent opened with a pointed line. This court has repeatedly reversed lower courts for failing to respect AEDPA's constraints, and today the court does the same thing itself. Gorsuch's first argument, Mississippi exercised its lawful authority to craft preservation rules for Batson claims. Ford versus Georgia, a 1991 case, explicitly told states they could develop their own Batson procedures. Mississippi built a consistent rule: raise pretext arguments before the trial court or lose them. Nothing about that rule defies clearly established federal law.
And the dissent's reading of the trial record?
Very different from the majority's. Gorsuch argued defense counsel never actually tried to make a Step 3 comparative juror argument, the kind that says the prosecutor treated white jurors with similar characteristics differently. What Steiner sought to reserve at the close of jury selection, the dissent argued, referred only to the Step 1 statistical argument she had already made, that the prosecutor struck black jurors at a higher rate. The dissent pointed to a devastating piece of evidence. In post-conviction proceedings, Steiner herself filed papers swearing that she failed to challenge the prosecution's reasons as pretextual at trial and that she did not do anything to reserve that pretext argument.
Ouch. The defense lawyer herself said she didn't make the argument, and the dissent drove home the AEDPA standard. Under Section 2254 D.2, it's not enough that Pitchford's reading of the record qualifies as plausible. The record has to compel it. Citing Rice v. Collins, a 2006 case, Gorsuch said Pitchford couldn't clear that bar. The Mississippi Supreme Court and the Fifth Circuit both read the record the same way. At oral argument, Justice Alito made a similar point in pointed terms. He said this trial lawyer was the most timid and reticent defense counsel he had encountered, and that any competent defense attorney he knew would have spoken up.
So the dissent's bottom line.
The dissent's bottom line. The majority's opinion errs on the law and the facts alike. Gorsuch offered one consolation. Because the majority left so many AEDPA precedents unaddressed, its ruling carries limited precedential weight. It decides only that Pitchford didn't waive a Step 3 argument, without dictating what further proceedings on remand should look like.
Let's get to what this actually means. So what actually changes after this decision?
For Terry Pitchford, this ruling means his case heads back to the lower courts for the first real Step 3 Batson examination in more than 20 years. The core question on remand: did prosecutor Doug Evans's stated reasons for striking 4 black jurors actually hold up? Or did he treat similarly situated white jurors differently? And that comparison matters enormously. 3 of the 4 struck black jurors never received a single question from Evans during jury selection. He removed them without ever speaking to them. If white jurors shared the same characteristics he cited, similar family situations, relatives with criminal records, and Evans left them on the panel, that comparison becomes powerful evidence of pretext.
For other defendants on death row who received the same procedural treatment, trial court skipped Step 3, state appellate court called it a waiver. This ruling opens a door. It says AEDP, a deference does not protect that combination of errors, at least when a trial court also affirmatively assured defense counsel the objection was preserved.
And for trial judges everywhere, the message is direct. You carry the primary responsibility for enforcing Batson. The court's line from Flowers echoes through this opinion. The job of enforcing Batson rests first and foremost with trial judges. A judge who runs Steps 1 and 2 and skips Step 3 doesn't satisfy that obligation.
What the court left open?
2 big things. First, the court said nothing about whether Evans actually discriminated. That question, and the appropriate remedy if he did, go back to the lower courts. Second, the court left open what form of relief Pitchford would receive if he prevails on remand: a new trial, a new sentencing, or something else. The dissent flagged that too, noting the narrow scope of the holding.
And there's a broader backdrop here that your listener should carry out of this episode. Doug Evans, the prosecutor at the center of this case, appeared before the Supreme Court twice now for racially motivated jury selection. Flowers versus Mississippi in 2019 involved the same prosecutor, the same county, and conduct the court called a relentless, determined effort to rid the jury of black individuals across 6 trials of the same defendant. This time, the court ruled the process broke down before the scrutiny even started. The question on remand: does what Evans did in 2006 at Pitchford's trial survive the examination he never faced?
And the answer to that question could determine whether Terry Pitchford lives or dies.
It could. This one's not over.
Thanks for listening to today's High Court Report episode. Remember, Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And if you found this episode useful, share it with someone who follows Supreme Court cases, or share it with someone who doesn't but probably should. Talk to you soon.